Question number 1. Assertion. The principles of equality before law means that there should be equality of treatment under equal circumstances. Reason. All persons are not equal by nature, attainment or circumstances. Find the correct response. Here the correct answer is correct. Option 1. Both A and R are true and R is the correct explanation of A. Now let us see the question number 2. The Vice President of India is elected. Answer is by electoral college consisting of all the members of both the houses of parliament in accordance with the proportional representation by means of single transferable vote and by secret ballot. This is the correct answer. Prorogation of the house means the session of the house has been terminated. Question number 4. Give correct response regarding the procedure of passing of bills in parliament. Options are: a bill pending in parliament shall not lapse before the propagation of two houses of the parliament. Option 2. A bill pending in Rajya Sabha which has not been passed by the Lok Sabha shall lapse on its distribution. Option 3. A bill pending in Lok Sabha shall not lapse on dissolution of Lok Sabha. And option 4. A bill pending in the Rajya Sabha which has been passed by the Lok Sabha shall lapse on the adjournment of the Rajya Sabha. Here the correct answer is option 1. That is, a bill pending in parliament shall not lapse because of the prorogation of two houses of the parliament. Question number 5. Which of the following is not covered under Article 20 of the Constitution of India? Options are ex post facto laws, preventive detention, double jeopardy and self-incrimination. Here preventive detention is not covered in the Article 20 of the Constitution. Article 20 talks about the protection in respect of conviction of offences. Article 20 clause 1 talks about the ex post facto law and dual jeopardy. Article 20 clause 2 and self-incrimination is given under Article 20 clause 3. Question number 6. Which one of the following statements is correct? A joint session of the parliament shall be convened by the speaker under Article 108, presided over by the senior most member of the house, convened by the president under Article 108 to break impasse in the passage of a bill. Here option 3 is the right answer. Article 108 talks about the joint sitting of parliament called by the President of India. Question number 7. Which one of the following pairs is correctly matched? Options are writ of habeas corpus available against private individual as well, writ of quo warranto available against subordinate courts only, writ of certiorari available against autonomous bodies only, and writ of prohibition available against public servants only. Here the correct match is option 1, that is writ of habeas corpus available against private individual as well. Question number 8. Which one of the following is not an automatic consequence of the proclamation of emergency? Suspension of enforcement of fundamental rights except those conferred by Article 20 and 21. Extension of union's executive power to issue directions to any state as to the manner in which the executive power has to be exercised. Option 3. Extension of power of parliament to the making of legislation in regard to the items of the statelets. And option 4. Suspension of Article 19. Here it has been asked which of the following is not an automatic consequence. That's why the option first will be the right answer. Question number 9. Indirect interference in the field of another legislature is known as obiter dicta, non-compos, harmonious construction, colorable legislation. Correct answer is colorable legislation. Question number 10. Consider the following statements to answer this question. Parliament cannot extend the jurisdiction and power of the Supreme Court. No discussion can take place in Parliament with respect to the conduct of the judge of the Supreme Court and discharge of his duties. A retired judge of the Supreme Court cannot appear or plead in any court or before any authority within the territory of India. The salaries and allowances of the Supreme Court are fixed by the Constitution and charged by the Consolidated Fund of India. In this question, correct answer is option 1, that is B, C and D. Only A is not correct. Question number 11. A question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine while B says it is forged. Here, option first, A can prove a statement by himself that a deed is genuine. Option B, B can prove a statement by himself that deed is forged. And option 3, both 1 and 2 are correct. And option 4, both 1 and 2 are wrong. In question number 11, option 4 is right. That is, both 1 and 2 are wrong. Question number 12. Recovery made by a police officer under section 27 of Evidence Act before recording the formal arrest of the accused is legal, illegal, irregular and improper. Correct answer is legal. Section 27 of Evidence Act talks about how much of information is received from accused may be proved. Now let us see the question number 13. Question number 13. Assertion. Even for a child born immediately after marriage, presumption of legitimacy under section 112 of the Evidence Act would apply. Reason. The legislature which extend the period of operation of the presumption by 280 days after dissolution of marriage did not choose to exclude any minimum initial period of matrimony for the application of the presumption. Here the correct answer is option first, that is both A and R true and R is the correct explanation of A. Section 112 of the Evidence Act talks about the birth during marriage, conclusive proof of legitimacy. Who among the following is liable to explain the injuries to the accused in a murder trial? Correct answer is prosecution. Question number 15. A client says to B, an advocate, I wish to obtain possession of property by use of a forged deed on which I request you to sue. Here the correct answer will be the communication is not protected from disclosure. Now let us see the question number 16. Confession of one accused is admissible against the co-accused if they are tried jointly for the same offense. Question number 17. Mark the incorrect statement. The terms relevancy and admissibility are coextensive and interchangeable terms. This is the incorrect statement. So first option is the right option. Section 91 of the Evidence Act permits admission of oral evidence to prove contents of a document where the writing is a fact in issue. Prohibits admission of oral evidence to prove the contents of a document where the writing is a fact in issue. Prohibiting admission of oral evidence to prove the contents of a document where the writing is not a fact in issue and is merely a collateral memorandum. Both second and third. Correct answer is option second. Prohibits admission of oral evidence to prove the contents of documents where the writing is fact in issue. Question number 19. In which of the following is not correct? In a rape trial, evidence of previous good character of the accused is relevant. In a rape trial, evidence of character of the victim is not relevant. In a rape trial, evidence of previous sexual experience of the victim is relevant. None of these. Here, third answer is right. In a rape trial, evidence of previous sexual experience of the victim is relevant. Question number 20. Which of the following facts the court may presume to exist? Option. When a woman states in her evidence before the court that she did not consent for sex. Option second, a child will never lie. And option third, a priest will always speak truth. And option four, all of these. Here the option first is the correct answer. When a woman states in her evidence before the court that she did not consent for sex. Question number 21. Delay in filing within a prescribed period may be condoned by the court upon showing sufficient cause under section 5 of the Limitation Act in the case of suit, appeal, and application under order 21 and all of these. Correct answer is suit. Question number 22. For exclusion of time of proceeding bona fide in court without jurisdiction, the time during which a former civil proceeding was pending, the day on which that proceeding was instituted and the day on which it ended shall both be counted. A plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. Misjoinder of parties or cause of action shall be deemed to be a cause of the like nature with defect of jurisdiction and all of these. Correct answer is option 4, that is all these. Question number 23. A gave a loan of rupees 1 lakh to B against a pro note which became due from payment of 1/1/2014. A dies on 31st December 2013, leaving behind a sole legacy heir S, who was born on 1st January 2000. When would the period of limitation for filing a suit for recovery of S shall begin to run? Correct answer is 1/1/2018. On 2018, he will become 18 years. Question number 24. In computing the period of limitation for any suit, the time during which the defendant has been absent from India will not be excluded, may be excluded in the discretion of the court, shall be excluded, none of these. Here the correct answer is option 3, shall be excluded. Question number 25. For a fresh period of limitation to begin from time of acknowledgement of liability under section 18 of the Limitation Act, it is necessary that the acknowledgement must be in writing, made before the expiration of the prescribed period, signed by the party against whom right is claimed, all of these. Correct answer is option 4, that is all of these.